Good morning. Glad to see you at the Rehabilitation and Social Services meeting. We have an interesting docket and only a limited amount of time this morning to get through it. So thank you for coming on time, colleagues. I will ask the clerk to open the roll.
You have a quorum, Madam Chair.
Thank you. Okay, I am going to turn to our first presenter, and I believe it's Senator Pillion. Colleagues, please turn your attention to Senate Bill 626.
Good morning, Madam Chair, members of the committee. Senate Bill 626. Madam Chair, as you and this committee are well aware, we have a mental health and substance use disorder crisis in this nation. Compounding the problem is a workforce that is overrun and stretched too thin. This bill recognizes those two realities and strives to bring balance and create a pathway to address both. I'm proud to be working with law students from UVA who are here today, and you'll hear from them in a minute, as well as Delegate Price, who is the vice chair of the Joint Subcommittee to study barrier crimes and criminal history records checks. In a recent survey, nearly 60% of respondents from DBHDS licensed organizations with peer recovery specialists on staff reported that peer recovery services were available but insufficient to meet demand in their region. In the same survey, 84% of organizations had trouble filling peer recovery specialists openings due to barrier crimes. We all know someone or of someone who has struggled and, as a result, made some poor decisions that had negative consequences for themselves and others. Now, I want to be clear. This bill does not ignore those consequences, nor does it undermine existing law. Sorry. It does create a post-conviction pathway to employment for those who meet certain criteria and may have a calling to help others who have been in similar situations. Virginia is the most stringent, with 176 barrier crimes that prohibit individuals from seeking employment, regardless of time elapsed from the last conviction, and if they are successfully undergone recovery. A waiver process was attempted. However, it was too cumbersome through the administrative process and virtually unworkable. Therefore, Senate Bill 626 permits DBHDS, providers of substance abuse or mental health services to adults, and CSBs and behavioral health authorities to consider applicants convicted of certain barrier crimes, provided such conviction occurred more than 5 years prior to the application date for employment. The bill also allows the department or hiring agency to establish additional criteria to screen applicants so that the employer has some additional flexibility to ensure an applicant is the right fit for the job. In closing, Madam Chair, at the appropriate time, I think there are several people here who can have more technical information for you, or perhaps some lived experiences or expertise, but I hope that we can see this as a vehicle for addressing a clear workforce challenge here in the Commonwealth and a pathway for hope for many Virginians.
Madam Chairman?
Senator McDougall?
Unfortunately, I have to run up to our Capital Outlay Subcommittee, but I just want to ask Senator Pillion one question. You asked me to be nice, so I will. But if I understand it, there's 4 separate categories that are being changed or removed from being a barrier. And there are a simple possession of drugs, which I personally agree with. There's obtaining drugs by fraud or deceit or forgery, which would typically occur in a prescription sort of way, which is I would also agree with. There's simple assault, and then there's the one that I have concerns about and is probably one that would prevent me from voting for this, and that is the distribution, including distribution of things like 100 grams or more heroin, 500 grams of other substances, things like that of distribution. That's also any distribution, even if you're a kingpin.
No.
Well, that's in the code section. So that's because all distribution is in that 18.248. So that's my question and would be my concern. But the other three, I think, are very logical and well thought out.
Senator Pillion, do you have a response?
So the distribution that I think he's referring to captures 763 individuals, and that's the reason that was included.
These would be, I just want to clarify.
And it's 5 years for any violation of 3 drug offenses, except for 2 provisions related to the leadership of a large-scale criminal enterprise.
It does kick out the H1 and H2, so that, David May, do you have any thing you want to add to this?
Madam Chair, no, not particularly. I was going to note that we did kick out H1 and H2. It does include the rest of it, but.
But, Madam Chairman?
Yes, Senator
But
McDougall.
It still includes C, which are multiple violations of, is that correct, Mr. May?
Madam Chair, Senator Verdugo, that's correct. It also includes regular H as well before you get to H1.
So if it was,
Senator McDougall.
if it had been distribution of marijuana, you'd probably have me.
You would be fine. Are you offering an amendment, or can we hear the entire presentation?
Madam Chairman, I just unfortunately triple booked this morning, but I just wanted to, I think this is a really good idea, and it is very, I think what Senator Pillion said about peer recovery groups and having access to individuals who have suffered with addiction is really important, and so I don't want us to lose sight of that part of this as we go through it. Some of us feel like the distribution part makes it different for particularly things like fentanyl, and so that's a policy decision for the committee, but that's where I am on it. Okay. If those things are included, I'm not going to be able to support it. If they're not there, I think it's an excellent idea.
Well, let's hear
Madam
from...
Chair, I welcome the committee to amend as needed.
To amend that?
Madam Chair.
Yes, Senator Jordan.
Thank you, Madam Chair. I would like to say, I think if this would work as a possible substitute, would we like to add in, if we'd like to keep that provision in, provided the person has completed intensive rehab or rehabilitation? Would that be helpful to the patron?
Well, it is 5 years post-conviction.
Senator Pillion.
Madam Chair, Senator Jordan, the bill does stipulate that it's 5 years post-conviction, all fines are paid, court costs. So there has been a period of time that they have...
With no reoffense.
With no reoffense. Yes, Madam Chair.
Do you have any further comment, or? Okay.
Madam Chair.
Senator Jordan.
In most cases, I would assume that every single time someone is 5 years post-offense and they've paid their court fees and fines, they've probably been required to go through substance abuse rehab.
Senator
Madam
Pillion.
Chair, Senator Jordan, that would be correct.
Okay, well, let's hear from your speakers. I know somebody from the UVA Law School helped you. They've been very helpful. There's several bills presented to our various committees where the law students have had a hand in drafting them. Welcome.
Good morning, Madam Chair and members of the committee. As Senator Pillion mentioned, my name is Ryan Karp, and I'm a student in the State and Local Government Policy Clinic at UVA Law. The views expressed here today are my own. SB 626 safely and strategically narrows some of the current barrier crime restrictions that prevent otherwise qualified and appropriate individuals from joining the behavioral health workforce. SB 626 does this in 2 ways. First, it relaxes the restrictions on employment for peer recovery specialists and other behavioral health jobs by making individuals with misdemeanor assault and battery or all but the most serious violations of 3 common drug offenses in their criminal history eligible for employment after 5 years post-conviction. And one thing to note, as far as the questions from earlier, is that many of these the more serious offenses that are still covered by this law still have mandatory prison sentences that exceed the 5-year amount. So these individuals will already have served a lengthy amount of time, have been rehabilitated through that process as well. So even though on paper it might say 5 years, in reality, because of the prison sentences involved and other commitments that they must do, the time that would be allotted to them would be much longer than the 5-year amount that's in the policy. So just wanted to flag the intersection of that. In addition to the survey data Senator Pillion referenced, data from DBHDS also shows that these barrier crimes are among the ones that most often prevent individuals from securing employment in the behavioral health workforce. In fact, some of these are the top 2 and I think 3 of the top 5 over the last several years. Second, SB 626 prevents these qualifying violations of these offenses from triggering the burdensome screening process that currently applies to applicants with certain barrier crimes in their criminal history, while still allowing employers to establish appropriate hiring criteria. And so in summary, SB 626 will meaningfully increase access to behavioral health services for those receiving treatment and offer substantive work opportunities for those in long-term recovery, giving a second chance to the Virginians that need it the most. Thank you so much for your time.
I see there's some speakers here. I'm going to say 5 minutes for those in favor and 5 minutes for those who may oppose this. So, and that's total. So you may want to allocate your time. If experts are coming up first, you may want them to speak a little more, and then you all can say you agree, but I'll leave it up to you. Will the clerk please start the clock? Welcome. Please state your name.
Hello, my name is Jason Cox, and I'm a person in long-term recovery. I've also worked in the behavioral health, addiction, substance use field for the last 5 years. I'm currently just celebrated 6 years in recovery, and these barrier crimes have prohibited me from helping a lot of people. I have applied for state agencies. I've been told that, out of 146 applicants, I was the top pick. However, because of certain barrier crimes, and some of which were not even crimes, was just a stipulation on the list, like not being 5 years removed from release of probation. I was prohibited from working for that state agency and being able to amplify what it is that I was given, which is my experience. So I would just appreciate y'all's support on this bill so that others coming behind me can support as many as possible. Thank you.
Thank you.
Good morning, everyone. My name is Grace Robinson, and I am also a person in recovery, and I am a community organizer. The views I express are entirely my own, and I just wanted to also just remind you all that, just because these barrier crimes happen, like has been stated, these people have done what they need to do. They have served their time, and they have made their amends and done what they needed to do. And as someone in recovery, while barrier crimes are not a part of my story, I have seen firsthand in other people's lives around me how important it is to have people working in recovery who understand and are able to share that experience with others who need it the most. And if you can't get a job, you can't pay your bills, you can't live somewhere, you can't have a roof over your head, you can't pay for your prescriptions, your groceries, anything like that. So I really urge you to support this bill. Thank you.
Good morning. My name is Jimmy Christmas. I'm a clinical social worker, but I also operate a DBHDS license program. So I see the firsthand effects of the barrier crimes on people being employed. I'm going to keep it really short. Currently, right now, we have a wait list of over 25 clients that need to be served by peers. And if you think about just my organization, it has a wait list of 25, and we just look at that exponentially across the state of Virginia. That's how many people who are not being served by peers in the state of Virginia. Thank you.
Good morning, Madam Chair. Victor McKenzie, Executive Director of Sarah, Virginia. We advocate, educate, and support individuals and communities impacted by substance use disorder. We support this bill. I think there's two key components. We want to know that this opens up the pool of possible employees. This is not a guarantee. Employers can still put in place hiring practices, so this is not a guaranteed. I also have a handout I'll leave with the committee that shows the impact of different code sections on that pool.
My name is Jeremy, and I'm a person inside recovery, and basically here just to advocate for the barrier crime bill. And it's like for every one senator that's sitting in front of me, I know at least 15 people inside of recovery that want to work inside of recovery but cannot because of barrier crime. So that's like, if I do the math, that's 450 people inside of recovery that can't get jobs. And, that's probably enough to fill this room up. And, it's nothing like having somebody with lived experience of active addiction working with another person inside of recovery because they can understand them or relate to them in another way. And, I was in recovery too, and still inside of recovery, and recovery helped me out a whole lot. So I think it would be a good thing for this bill to get passed. Thanks.
Good morning, Madam Chair, members of the committee. My name is Martin Mash with Focal, Virginia. We are the state's only peer-run and peer-staffed education and advocacy nonprofit throughout Virginia. We recently conducted a study with the University of Virginia examining the impact of barrier crimes, and nearly 70% of study respondents licensed by DBHDS reported that they are unable to meet the demand for their peer recovery services. 45% believed that their clients or members had been negatively impacted by a lack of peer recovery specialists. And I'm running out of time, so we support the bill. Thank you.
Thank you. Good morning. I am Beth O'Connor, the Executive Director of the Virginia Rural Health Association. My organization has a federal grant to train and certify peer recovery specialists, but we have not been able to spend down your tax dollars because of these regulations. Each one of you has a constituent who is not able to find meaningful work. Each one of you has an employer who has positions that have not been able to fill. I ask you to change the barrier crime regulations so we can put more people to work in Virginia. Thank you.
Good morning. My name is Chloe Edwards. I'm the policy director at New Virginia Majority. This bill is personal to me. I'm the daughter of a recovering addict. My father recently celebrated 10 years in recovery in January, but I learned that his recovery journey, it wasn't linear, but he did pursue things like the making of amends, reconciliation, looking at your resentments, and fellowship and service. Today, he is a certified peer recovery specialist and employed in a workforce shortage area because he didn't have barrier crimes although he does have 6 felonies, he didn't face barrier crimes as a barrier, but he did face barriers to employment. Virginia has a significant workforce shortage. It's especially exacerbated in urban and rural areas. And by getting these folks into the workforce pilot, they are able to help other people, and service is a key pillar of any 12-step program. Thank you.
Good morning, Madam Chair. Bruce Cruiser, Executive Director of Mental Health America, Virginia. And we have seen the power of peer support to save lives. We fully support the bill. Thank you.
Do I have anybody online too? Okay. Go ahead.
Richard Walker, you may unmute and speak. They can't hear me.
Could you tell him how to unmute, perhaps? Senator Pillion, do you have any remarks? We're trying to assist the individual who wants to give us virtual testimony.
Folks, Richard Walker, founder and executive director of Bridging the Gap in Virginia, formerly incarcerated convicted felon. I've been working in the field of mental health since 2007. I support this bill because there are countless individuals like myself that have the lived experience that they can help others. We have an epidemic, an opioid and drug addiction epidemic here in the Commonwealth of Virginia and throughout the country. We should allow these individuals that are able to help individuals to come off the drugs and be able to move back and reintegrate back into society. Again, I support this bill. Thank you.
Thank you. Is there another speaker virtually?
Yes, Madam Chair, there is one more.
Good morning, ladies and gentlemen, Madam Chair, and members of the committee. My name is Danny Murphy. I serve as the State Director for Right on Crime, where we advocate for conservative solutions to reducing crime, restoring victims reforming offenders, and lowering taxpayer costs. Right on Crime strongly supports this bill. And as others have noted, the strongest advocates for substance abuse rehabilitation and recovery are those with lived experiences. Additionally, data shows that the number one, or at least one of the top indicators for reform and reduced recidivism is employment. And so this bill seeks to reduce barriers for employment for those with lived experience who can assist the substance abuse recovery community by providing personal services. And we strongly support that. This is a smart bill that will work to increase rehabilitation services for those affected by substance abuse. And so I strongly encourage the committee to approve
Thank you
this
so
bill.
much.
Thank you, Madam Chair.
David May has something that is a clarifying point to Senator McDougal's earlier query. David?
Madam Chair, yeah, it may actually be not clarifying, but more of a question. To me, it appears in 37.2-314, for example, that a conviction under 18.2-248, that there's already an exemption carved out for a barrier crime. I don't know if someone's here from the department, but subsection D reads, notwithstanding B, the department may hire for compensated employment at an adult substance abuse and adult mental health treatment program a person who is convicted of, skip down, any offense set forth in clause 3 of the definition of barrier crime in 19.2 through 9202, which includes 18.2-248, and you've got the carve out of H1 and H2 as well. And that language doesn't even have a time limit on it of 5 years. It just says that it was substantially related to your substance abuse or mental illness, and you've been successfully rehabilitated.
I believe that was my peer recovery specialist bill that passed last year, and it was for a felony-related drug possession. So if in fact that's correct, I think our current law already addresses the issue that Senator McDougal raised. Senator Pillion, did you have any concluding remarks? Or yeah.
Oh, no, just on that point. So in subsection B, 18.2-248 is in clause 3 of the larger barrier crime statute. That currently, the general rule is that's an absolute barrier. However, 18.2-248, except for those 2 offenses that we've set out in this bill, is part of the screening process currently in place. So individuals with those convictions currently can still become employed. It's just much more cumbersome than it would be under this bill.
Right. And there's still a screening process in here. I mean, the Department of Behavioral Health can establish criteria. So this bill really merely makes people eligible to be screened, and then they have to pass that threshold, and then of course they have to pass a threshold of a healthcare provider actually deciding to hire them. And in some cases, they still have to gain their 500 hours of supervision, which a clinical counselor needs. So there are, I mean, by the time you look at this in its totality, a much smaller number of folks who appear to be eligible will actually pass all those thresholds and be serving adults.
About 2,000 in the Commonwealth currently would be approved by this bill.
Thank you. Okay, colleagues, the bill is before us. Oh, I have a few people in the queue. Senator Rouse and then Senator Servell.
Thank you, Madam Chair, and good morning to the members of the committee and everyone. 2 questions, really quick. My first question is, how many bills, Madam Chair, is Senator Pillion going to carry for UVA? That's my first question.
Madam Chair, Senator Rouse, this would be the second one, and I would welcome him. I'm sure they would welcome a former Hokie to carry any of their bills.
And on a more serious note, Madam Chair, 5 years post-conviction and with all the court costs and court fees supposed to be paid, I'm curious into, do we have any data on how many of those who have been 5 years post-conviction but still have maybe astronomical court costs. Because obviously drowning in court costs, I'm sure many won't be able to or haven't been able to pay down court costs within 5 years if they've been unable to get a job.
Madam Chair, Senator Rouse,
Senator
I do not have that information, but I included that in this piece of legislation because this bill has to pass through a different body and be signed by the governor into law. So I do know the limitations that present themselves.
Yes, we always have to take certain strategic steps to move a reform.
Yes, thank you, Madam Chair. I just don't want it to be lost. I think it's a very good bill, but I also don't want to be lost on this committee, as well as the hurdles when it comes to court costs and fees associated that really drowns a person out from true rehabilitation and being reintroduced into society, where they're able to put a roof over their head, food on their table, clothes on their back. All of those things are very helpful in stopping recidivism. And so I just want to make sure we, perhaps next session we can look at court costs and fees and eliminate what that would be.
Thank you, Senator Serval, and then Senator Williams-Graves.
Speaking to the bill, Madam Chair.
Senator Serval.
Thank you, Madam Chair. So, first of all, I want to thank the students from the greatest law school in America being here to help us make policy. You guys do an awesome job. And the second thing is, this, I think I've been hearing these bills for 9 years that I've been on this committee. And for those of you who are out there, please look at section 19.2, 392.5. Because starting July 1 of 2025, if anybody obtains the ceiling of a conviction, which is a law we passed in 2021, it operates to lift barriers to all employment, not just this. It includes this, but everything, class 5, class 6 felony, all the way down to misdemeanor, excluding domestic violence and DUI. And a lot of people aren't aware of that because it's taken us 4 years to implement the law because we had to redo our criminal computer system to make it cheap enough to process. But any felony, not just substance abuse, any felony, class 5, class 6, class 1, all the way down is going to be covered by that starting July 1, 2025, if you can meet the grounds for sealing. This bill is a little different. Sealing requires a 7-year wait. This is only 5. Sealing, you can only do 2 events in your life. If you have more than 2 events, then you can't get all the crimes sealed. But anyway, this is a little bit different way to go at it. But I think most of this stuff would be covered by the sealing statute if you only have 1 or 2 convictions, and it's been 7 years. So in any event, I think a lot of the pressure is going to be relieved when that bill goes into effect in July 1 of next year, not this year. But I'm glad we're finally starting to focus on this and get some work done. So I'm happy to support the bill, and I'd move to report it at the appropriate time, Madam Chair.
Senator Williams-Graves.
Madam Chair, speaking to the bill.
Go ahead, Senator.
Thank you. Senator Pillion, I really like this bill. State jobs and mental health jobs, those are all really good jobs. They provide stable employment and retirement benefits and things that everybody needs, but especially those who are struggling to recover and get their lives back and stay on the right track. So I also agree with a lot of the witnesses, and I thank the witnesses that came and kind of put themselves out there that have personal lived experiences, because I'm pretty sure that's probably not the easiest thing to do. So thank you for coming and sharing with us, but lived experience beat textbook experiences every day of the week. So I think this is a great bill, and I'm not surprised that Delegate Price is working with you on it. And so Madam Chair, at the appropriate time, I'd like to make a motion.
Go ahead.
Madam Chair, I'd like to make a motion to report. Does this have to go to Finance?
It does not have to go to Finance, which is surprising, but it's a clean report. And Senator Serval, did you second that motion? Second. Okay, will the clerk please open the roll? Does anybody have the proxy for Senator? Okay.
Ayes 11, noes 4.
Thank you, Madam Chair.
Your bill will go to the floor. Thank you. Okay, next in the sign-up sheet is Senator Eben.
Good morning, Madam Chair, members of the committee.
Before you is SB 676, a bill to direct the Department of Medical Assistance Services to amend the financial eligibility standards for certain waivers providing services to individuals with developmental disabilities so that Social Security disability insurance income is disregarded by the department when calculating such individuals' financial eligibility for such waivers. And I think it's important to point out as we begin this discussion that CMS guidance has changed in the last year or so, and this is now allowable. Currently, disabled Virginians, however, with a Medicaid-funded waiver to pay for group homes, community supports, and services to build up their independence, have a monthly maximum income limit of no more than 300% of the maximum SSI to maintain this waiver. For 2022, that was $941 a month, so the maximum income from all sources was $2,300 a month. So most waiver recipients begin their time on a waiver receiving only personal SSI, and if they're able, they can work and earn a modest income of amount of income while still staying well below the income cap for receiving their Medicaid. As you can imagine, having the opportunity to have a job can be incredibly meaningful to the individual and impactful benefits both physically and mentally for those living with disabilities. So we received new authority from CMS in 2019 on how to count SSDI income specifically for waivers. And for many years already, people with DD waivers have had to reduce their working hours or quit their jobs entirely when their parents retire or pass away to keep their gross income under the waiver income cap. So this year, 2024, is the first year that a parent passing away can leave enough in SSDI retirement benefits to the child that the child will immediately become ineligible for the waiver. As wages and retirement ages increase, this will become more and more of a pertinent issue. So this is alarming and a terrifying outcome for parents, especially as they do their own financial planning. This plan costs Virginia nothing and will in fact save the Commonwealth money over time as people will now be co-paying greater amounts based on SSDI income stay in the waiver program. So I have with me today a parent, Dennis Finley, who can provide some greater details about his own experience dealing with this, and there's some parents and advocates who wanted to speak to the bill both in person and online.
Okay, this is actually the Disability Advisory Commission heard this topic in great detail, and it actually is just directing the department at the moment to come up with an amendment plan, which of course the Finance Committees always look at if we're amending our Medicaid plan. This has been new information from the Centers for Medicare and Medicaid, which I think is helpful. I understand from my last briefing we can now apply the SSDI income disregard to a category of Medicaid recipients, to the DD waiver category, which significantly reduces the prospective impact. Thank you, Senator Eben, for carrying this. And I do know Dennis Finley, and I think if Mr. Finley wants to come up and say a few words, please limit your comments to 2 minutes. And then those of you who agree, if you could just come to the podium and say you agree, that would be helpful. I think this bill is in good shape, unless I sense otherwise. Mr. Finley.
Madam Chair and members of the committee, thank you very much. I'm Dennis Finley from Fairfax. My wife died in 2010 when my disabled son was 14. When he was 18, Social Security gave him SSDI instead of the normal SSI. They explained he was required to take SSDI survivor benefits on his deceased mother's work record. Those benefits were 3 times more than SSI. In 2018, he was awarded a community living waiver and moved into a group home. It was then we discovered he could not have the meaningful life job he had been trained to do. Why? Because SSDI on mom's work record, a death benefit from the feds, was too close to Virginia's Medicaid income cap. It was now a death penalty. In 2019, Congress passed the Sustaining Excellence in Medicaid Act. It's a fix for income-related problems with Medicaid for disabled individuals like my son. As you heard, CMS then issued new income disregards in 2021 for states to implement. The new policy rules are innovative. For the first time in the 50-year history of Medicaid, states can now make changes for designated groups of Medicaid recipients who receive home and community-based services without having to change it for all Medicaid recipients or even for all waiver recipients. It also directs more Social Security dollars to states for disability care. Patient pay is a waiver recipient's contribution to the state to help cover the cost of the care. It's based on the individual's income. The fiscal impact statement for this says the cost of Virginia is minimal, but doesn't count the money to the state from increased patient pay. In reality, it's budget positive. Please support this bill to eliminate the SSD income penalty. So I can now answer the constant question from my son, Dad, can I get a job? Yes, Sterling, let's go find you a job. Thank you very much.
You have been a very effective advocate, Mr. Finley.
Madam Chairman, members of the committee, I just wanted to say hi. My name is Mark Williamson. Some of you may know my son, Tyler Williamson, who runs a charity in Tidewater called Families of Autistic Children of Tidewater. I know, talked to Senator Graves. I fall in the category of people whose son will be disqualified completely when I pass and he gets 75% of my Social Security income. My son is not in the jobs category. He is severely autistically disabled. He has MS, he has epilepsy. If I die going off this table, he'd lose all these benefits that he's gotten for 25 years. This is unfathomable. I appreciate your support.
Thank you.
Madam Chair, members of the committee, my name is Diane Corsello, and I live here in Richmond, Virginia. My son is 31 years old and on the autism spectrum. He works at Bon Secours Mercy Health and has been there for 8 years. He pays his medical and dental benefits through his job. He will need to quit his job when my husband and I begin collecting Social Security. And worse yet, he will receive no services when we die. So I fully support this bill. I think it is great for the individuals that are on this disability waiver, and I ask for all of your support. Thank you.
Good morning, Madam Chair and members of the committee. I'm Ann Flippen, Executive Director of the Autism Society of Central Virginia and sibling to a young man with autism that this impacts. Very grateful to the patron for bringing this forward, and we strongly support the bill.
Good morning, Madam Chair. My name is Brian Kelmar. On behalf of Commonwealth Autism, we support this bill. And as a parent advocate of a 32-year-old son, when I die, he would lose his benefits. His autism doesn't go away. He still needs social supports. Thank you.
Good morning, Madam Chair, members of the committee. Tanya Milling, Executive Director at the Archival of Virginia. We very much support this bill. Thank you so much.
Morning, Madam Chair and members of the committee. I'm Dr. Harry Gawanter, and as much as I would like to say that MSV is supporting this, I cannot say that. But I am here because I take care of kids with disabilities, and I have a 38, almost 39-year-old son with disabilities who has Down syndrome. He works, he lives in a group home, courtesy of the waiver. When my wife or I pass, he will not be able to do that, and that will be devastating to him. Please support this bill. Reminder, it is a clash between federal regs and state regs, and it's a positive income for the state. Thank you.
Good morning, Maureen Hollowell with the Virginia Association of Centers for Independent Living, and we support the bill. Thank you.
Madam Chair, members of the committee, Terry Morgan with the Virginia Board for People with Disabilities, and we strongly support this bill. Thank you.
Madam Chair, Randy Pearson with Two Capitals Consulting on behalf of the Autism Society of Tidewater, Virginia. We strongly support the bill, and thanks, Senator Eben.
Do we have any speakers online?
Yes, Madam Chair, you have 6.
I would ask the 6 speakers to just say your name and the group you represent and whether or not you support the bill.
Pam Spiring.
My name is Pam Spiring, and I support this bill.
Thank you.
Donna.
My name is Donna Burnett. I'm a parent advocate for Brett Carroll, and I support this bill.
Lucy.
Lucy Beednell with the ARC of Northern Virginia. Strongest possible support for this bill.
Mark.
My name is Mark Albert. I'm a parent of an adult with disabilities. My biggest fear is what would happen to my daughter after I die. It's practically a full-time job to try to maintain her benefits. For this to pop up upon my death, that she suddenly loses her benefits, would be devastating. I speak in support of the bill.
Thank you.
Sheila. Sherry.
Hello, Senator Favola. You've heard from me a lot, and I was on the phone with Social Security for 2 hours last night because I want to retire at age 70, and got the great bad news that my son will be able to work a total of 3 hours after I retire. He has 19 years at Safeway, 2 years at Vitality Living, and please don't let him make him have to give up work so that because of my income. Thank you.
Thank you.
Madam Chair, Sheila was muted. Sheila, could you unmute?
Yes, Sheila Billingsley, mother of a 36-year-old autistic son. I strongly support this bill.
Thank you. I think that concludes our testimony. I don't hear anybody in opposition, and this is much needed, so I'd like a motion, and it has to be re-referred to Finance.
Madam Chair, move to report and re-refer to Finance.
Okay, will the clerk please open the roll?
Ayes 15, no 0.
Thank you, Senator Eben.
Thank you, Madam Chair, members of the committee.
Next is Senator Marsden. Senator Marsden, your bill is Senate Bill 449.
Thank you, Madam Chair. Senate Bill 449. As some of you may remember, several years ago, we passed legislation that I sponsored to provide, after 20 years of incarceration for a juvenile sentenced as an adult, that they would be able to receive a parole hearing. It was their only really exemption to the no parole statutes in Virginia. And it is, while there aren't many folks being released, there have been some really great success stories of young men who have gotten out after that 20 years of incarceration for doing some things that are, quite terrible, but they've turned their lives around. What we have here is trying to close a loophole. We had a young man who ended up on 2 separate sentencing strands where things weren't legally consecutive, but they weren't ordered to be concurrent, but they ended up being consecutive, and he thought he was going to be getting released, and then he finds out from the Department of Corrections that he's got 3 more years to pull because they could not count his juvenile sentence. Ordinarily, what happens with juveniles under the blended sentencing law that I got introduced and passed back in 2001, a youngster goes under a blended sentence, goes to the Department of Juvenile Justice to continue his education and treatment. At the age of 20, the case can be reviewed by the circuit court judge prior to his going to DOC for any amendments to the Senate, and then he goes and completes whatever sentence he had. And of course, many of these were life sentences, and of course, life was without parole. So this was an exemption to it. But what this one young man got caught up in, and it could happen again, is that he was involved in a number of incidences and ended up with a circumstance where he was continuously incarcerated for over 20 years, but they weren't concurrent, and because it was 2 separate situations. And so he did his 20 years of incarceration, but was not eligible for parole. And I've worked with the Department of Corrections, and they have helped create this language to close this loophole if it happens again to some young person, because the goal of the original bill was after you've been incarcerated consecutively for 20 years, you ought to get a look from the parole board. Not any guarantee of getting out, and very few have. But that's what the bill does. It's just designed to close that loophole.
Thank you, Senator Marsden. Do you have any speakers with you? Does anybody wish to speak in favor? Does anybody wish to speak in opposition?
You have one online, Madam Chair.
Okay, please open the virtual platform.
Richard Walker, you may unmute and speak.
Again, Madam Chair, Richard Walker, Executive Director, Bridging the Gap in Virginia. I worked with individuals that went in as juveniles, and I can give you a success story of a young man that came out. He's gone through our solar panel installation trainer, and now he is a solar installation technician for a major solar company. I highly support this piece of legislation to close that loophole to give other young men the opportunity of coming back and being reintegrated back into society. Thank you.
Thank you.
Lucy Beedno.
Lucy Beednell with the ARC of Northern Virginia, recognizing the significant disproportionate impact of people with developmental disabilities who are incarcerated, often in juvenile centers, and who have particular difficulties navigating logistical hurdles. We strongly support this bill.
Do you have any concluding remarks? It's a very straightforward bill. I like it.
It is, Madam Chair, just designed to fix this situation so it doesn't come up again. And I think because I was notified of this in the past year, he had 3 additional years. If this bill goes into effect on July 1, he would be eligible for a parole hearing to determine whether he has earned his way back into society. And that's all it does, is make sure that everybody's treated fairly who does 20 consecutive years of confinement.
And it only makes them eligible for parole, which is
only eligible.
Yeah. Okay, motion has been made to report. Is there a second? Will the clerk please open the roll?
Ayes 8, noes 6.
Did Senator Jordan have a proxy? Okay.
Unit says that the proxy was given to me, but I don't hold her proxy.
Did you leave the room? All right. Well, why don't we, with unanimous consent?
When she gets back, she can have her vote when she gets back.
No, his proxy works.
Sorry, that was just, I have that. Emily, I'm not sure what she was saying.
Okay, so there's no need to reopen the roll, and it does not have to go to finance. So according to the clerk's record, is it 8-6? Okay, your bill reports.
Thank you, Madam Chair, members of the committee.
Thank you. I did have Senator Pekarsky next, but I don't see her here. Could you text her? Yes. Okay, and I will go ahead and let me, I see Lamont, yep. Before I get to Lamont, I do have a housekeeping matter, and I ask unanimous consent, or we can go on the board. Senate Bill 417, a bill by Senator Head, he asked that it be continued to next year. I believe we have to open the roll for that. Is there a second? Clerk, please open the roll.
Ayes 13, noes 0.
Okay. And Senator Bagby. Good morning.
Good morning, Madam Chair.
And this is Senate Bill 719, and it will have to go to Finance, just for my colleagues.
Yes, Madam Chair. Yes, Madam Chair, and this is a bill that many of you are familiar with in some form or fashion. The purpose of this bill is to end the prolonged use of what we most of us know as solitary confinement in Virginia prisons, and require pro-social programming that will help rehabilitate those incarcerated while providing more transparency on the use of solitary confinement, or restorative housing, as it's known as in Virginia. Specifically, it puts a time limit on the number of days someone can be kept in these extreme conditions. It refines the out-of-cell time to ensure that people held in solitary are able to access meaningful programming so they are able to be rehabilitated. And Madam Chair, this legislation was presented in House Committee yesterday, and we looked at a little bit of the discussion in the House and noticed that some of the discussion led us to put in an amendment. And so I believe
Offer that
has the amendment.
Okay. Do you have a copy?
I do.
Okay. So colleagues, an amendment is being offered by the patron. May I have a motion to accept it? Okay, all those in favor signify by saying aye. Aye. And David, could you explain the amendment?
Okay, yes, the amendment simply adds another exception in Section B, and it simply says, or in individual cases when medical isolation as documented by a licensed medical professional.
Okay. Could you just...
And so it offers an
that
opportunity for those individuals that need medical assistance to receive that medical assistance.
So that's a small 5. David, May?
Madam Chair, I actually added it as 4, but yeah, it's 2 line amendments total. On line 45 after designee semicolon, we would insert a new 4. That would be an exception for the placement is necessary for medical isolation as determined and documented by a licensed medical professional. And then the other amendment is just clean up on line 45 to strike the Romanet 4 and change it to a 5.
Okay. Well, we've already adopted that.
Yes, Madam Chair. And in closing, one other additional thing that it does, it requires the Department of Corrections to track and publicize the use of lockdowns.
So this actually, I guess the key thing here, it's limiting confinement for no longer than 15 consecutive days, including investigative time in any 60-day period, and this would be isolated confinement.
Correct.
Okay. And I guess last year we passed a version of this bill without the time limits that talked about the need for time out of the isolated cell, educational opportunities, et cetera, et cetera. So that's still our current law. Do you have speakers in favor of this bill? And I'd ask each member to keep your remarks to no more than 2 minutes.
Thank you. My name is Natasha White, and I'm a directly impacted, formerly incarcerated survivor of solitary confinement and the Director of Community Engagement at IHR. I support this bill because incarceration should be rehabilitative. There's nothing rehabilitative about locking somebody in a cell for long periods of time for years and years and years. If anything, it just exacerbates the issues they already have, and it just does not address the underlying issue at all. Chaining people to desks, putting people in cages for recreation, none of that is the goal or should be the purpose of the Department of Corrections. Thank you.
Welcome.
Good morning, Madam Chair and Committee. My name is Sheba Williams, Executive Director of No Left Turns. In 1992, my ex-husband was sentenced to 74 years at the age of 15, and when he first got to Southampton, he was the youngest in the state to be in that facility. They confined him to solitary confinement for 10 months just because of his age, not because there was a threat to the facility. The 95% of individuals that return home from Department of Corrections come back to this community with behavioral health issues that cannot be addressed. And at the age of 45 now, he still suffers from behavioral health issues. So I support this bill. Thank you.
Madam Chair, members of the committee, thank you. I'm Taj Mayenhef, Director of the Humanization Project, also a survivor of 14 consecutive months in solitary. We support this bill because it's important to end the extended use of solitary that, even under the best of conditions, medical, psychological professionals have clearly indicated is detrimental to people, not helpful, and has been called torture by the United Nations Human Rights Commission and has inspired hunger strikes right now in Red Onion. These are conditions that must be considered and ended. Also, this works. Everywhere it's been done in states as disparate as Mississippi and Massachusetts, reducing solitary not only saves millions of dollars, and the DOC has been spending millions of dollars defending solitary recently of taxpayers' money, but it does not lead to increased violence, and staff is actually safer and happier afterwards. This works for everybody. It's also worth noting that a lot of the details here are just to codify existing best practices that the department already has in their policies, but to make sure that they're actually being enacted. Because in a lot of situations, there's loopholes and language differences that are being wiggled around. And this just makes sure that last year's reforms, as intended, are actually reaching the people who they were intended to help. We thank you for that first step, and we ask you to take this next step. Thank you very much.
Thank you.
Good morning, Madam Chair
morning.
and committee members. My name is Kimberly Jenkins Snodgrass. I'm with Interfaith Action for Human Rights. I'm the Senior Advisor for Criminal Justice Reform. I speak to you this morning in memorial of John Horsch. This was his bill. He has transitioned, but solitary confinement has to prolonged solitary confinement has to end. Simply, I talk from experience. My son is incarcerated. He spent 4 consecutive years in solitary confinement, and that was without touch. Once I was able to touch him, he shivered. That was his first touch in 4 years. Another thing I noticed, he had no scent, no body scent. This, for me, I thought was the worst. But sometime at Interfaith Action for Human Rights, I get called from mothers. And to get a call from a mother whose son has passed away, transitioned, in solitary confinement. And in this case, it's still under investigation. How did he die? Because this was a young man. When you have an incarcerated child, you develop relationships. I know 4 women who have incarcerated children. All are now deceased. I'm the last one standing. I hope that you will support and pass this bill. Thank you.
Good morning, Chloe Edwards with New Virginia Majority. For all the reasons stated, we support this bill. We believe this is a great step in the right direction towards a rehabilitative, restorative journey for folks re-entering from society. This causes torture to individuals. It doesn't cater to their healing journey, and it doesn't cater to the right transitions they need upon getting out. For those reasons, we support this bill.
Thank you.
Madam Chair, members of the committee, Jeff Caruso with the Virginia Catholic Conference. This is the 3rd year we've supported this bill, and we're very pleased to do so. We think very strongly that there needs to be clear, concrete time limits on this practice, as this bill would do, so we urge your support. Thank you.
Thank you. Is there anybody in opposition to this bill? Again, keep your remarks to less than 2 minutes, please. Thank you.
Good morning, Madam Chair, members of the committee. My name is Rose Durbin, and I'm with the Virginia Department of Corrections, and we do strongly oppose this bill. When there's talk generally about solitary confinement in other states or the way that things were done historically within DOC, it overlooks the reality of actually what is happening within the department at this time. We are currently looking at about 68 individuals in max custody at Red Onion, which is essentially our what is being referred to by many as the long-term segregation unit. That number went down from 511 at one point due to the programming and opportunities for out-of-cell time that are provided to the individuals currently. As I indicated, hundreds of individuals have successfully transitioned out of that status. The average length of time that the inmates are currently in that status, working their way through the program to transition back out, is 4.3 months. Long before the bill passed last year, the department was already offering all inmates 4 hours of out-of-cell time, which was codified last year with the legislation, and we are currently in compliance with the code as it stands. And keep in mind that was a bipartisan effort last year. Inmates are offered a variety of out-of-cell opportunities, such as education programs, various activities, recreation, mental health services, during their time in the program, all with the goal of working their way out of that setting. Inmates are separated from the general population for security reasons within the facility, such as continuing violence against other inmates and staff. For example, in December of 2023, there was an inmate who stabbed another inmate at Sussex 8 times in the head and neck. That inmate who was attacked is now paralyzed. His aggressor is currently in Red Onion, working his way down out of the status that he is currently in to safely and responsibly transition back into the general population setting. But there are also success stories as well. Thank you. There's also success stories as well. There was an inmate in 2021 who attempted to kill another inmate in general population at Red Onion. That individual, based on that act, was placed into the setting we are discussing. He was able to successfully program and work his way out of that setting and has been employed as a barber and sanitation worker within Red Onion and is currently active and enrolled in classes for educational purposes within the general population setting. So lastly, we just oppose this bill because it limits our ability to support the inmate and develop a responsible and safe transition plan into general population. It limits our ability to have a safe, healthy, and productive environment for inmates and staff. We did ask our representative from the Attorney General's office to be here as well. She is behind me to provide some additional specific comments to the legislation.
Okay.
Good morning, Madam Chair and members of the committee. My name is Margaret O'Shea. I'm Senior Assistant Attorney General with the Office of the Attorney General. In that capacity, I've represented the Department of Corrections now in various capacities for about 10 years. I wanted to make sure that the committee is aware of the active litigation that is pending in federal court right now in the Western District of Virginia. It was filed in May of 2019, so it's been going on for almost 5 years, regarding the conditions of confinement at Red Onion State Prison and whether or not DOC's policies regarding long-term segregated confinement pass constitutional muster. That case is finally, after all this time, almost ripe for disposition. The parties have filed cross motions for summary judgment, and by communication we had just a couple of weeks ago, the judge indicated that he was intending to issue his opinion shortly, and the case would then proceed to trial. Considering that this body just enacted legislative changes last year, and considering that this litigation is almost ripe for final disposition, I would urge the body not to disturb the status quo of that particular case and allow that case to proceed to its conclusion and let the federal judge issue his opinion as to whether the conditions of confinement that now exist and that have existed are in fact constitutional. That said, I did want to mention that the Department of Corrections that stood before you today and that exists today is not the same Department of Corrections that it was 10 years ago. The enormous strides that have been made in this area are really quite remarkable. And one area that my colleague did not have the opportunity to touch upon was what the department has done for mentally ill individuals in their custody. Starting a few years ago, the Department of Corrections has been diverting seriously mentally ill individuals out of restorative housing. They're not allowed to be placed at Red Onion at security level S, and they instead go to specialized mental health units, which is important because although I certainly appreciate the amendments as to medical isolation, it doesn't speak to those individuals who, for mental reasons, might not be appropriate for congregate recreation and congregate programming. It would interfere with the discretion of the mental health professionals that are trying to manage those very specialized units, that very difficult population. So I would urge the committee to look at this bill, look at the reasons it's being offered and see whether the language in this bill actually accomplishes that purpose or whether it frustrates the security mission of the department as well as its mission to care for the inmates and the staff members in all of its facilities.
Thank you.
Thank you.
A couple of my colleagues are in the queue. Do you have questions, or were you ready to? Okay, Senator Williams-Graves.
Thank you, Madam Chair. To the patron, and also just thanking everybody that came again and gave their personal stories. I'm certain that was probably not the easiest thing to do, so thank you. To the patron, is there any penalty for the facilities for not following these rules?
Senator Bagby.
Madam Chair, I don't know what I don't think there is a penalty other than a lawsuit like what they're witnessing right now. And to that point, Madam Chair, I don't think the question is if it's constitutional. This is not why I'm bringing the bill. The bill is it humane? That's the reason why the bill is before you. And so if they're approaching everything as we're going to do whatever it is as long as it's constitutional, we're in bad shape. The question and the reason why these folks are here today is the question of humanity.
Senator Reeves, and then I think we should entertain a motion.
I just had a question for the Attorney General's office. When is that litigation from 2019? When do you anticipate a ruling to come down?
The parties had a status conference with Judge Jones about 10 days ago, and he informed us that it would be issued shortly. What shortly means to a federal judge is up to the federal judge, certainly. But we have fully briefed and argued these motions as of November, so I would anticipate in the next few weeks. The case was originally set for trial next month. Judge Jones had to take it off the trial docket because the parties wouldn't be ready to go to trial if we just got the summary judgment rulings, say, today, right? But I would anticipate it really in the next few weeks is when we're looking to get an opinion.
So Madam Chair, Counselor,
Senator
this
Reeves.
year?
Yes.
Okay, thank you, Madam Chair.
Yes.
I do remind my colleagues this will have to go to finance, so it won't be acted on immediately. Senator Perry.
Thank you, Madam Chair. I just have a question about some of the question I see in Section B. The language is added: no incarcerated person in state correctional facility shall be placed in restorative housing or isolated confinement by any designation for longer than 15 consecutive days, and then list out a bunch of exceptions. And I know we added, I think, an additional exception today. Things like, hey, I opt to be in isolated confinement because I'm concerned for my safety, or other reasons, right? And so. I support all of that. My question is, when we get down to, so it seems like there are reasons why I could be there for longer than 15 days, including that I want to be there for my own safety. It makes me feel better or whatever. But when we get down to 5, then B5, my question is, is that an exception to the exception for the reasons I can be there? I guess maybe it's my misunderstanding or confusion about it. Because it looks like in B5, it looks like I can't stay there for more than 15 days. It looks like an exception to the exceptions for why I could be there, if that makes any sense.
I would ask, if you don't mind, David May, I would have him respond.
Madam Chair, Senator Perry, that is exactly what it looks like. I'm not sure that I think that's a hard cap on it, even if you are under the exception.
Okay. So, Madam Chair, so just so I'm clear, I know that sometimes people who are getting ready to be released opt to go into isolated confinement and things like that because they want to make sure nothing happens that messes with their release date. And so they would not be able to do that if their release date is more than 15 days out. Is that right?
Madam Chair, Senator Perry, I think this would only apply in situations where they were in there for imminent threat of physical harm. But if that's what was being used to effectively get that done, then I would say yes, they wouldn't be able to do it more than 15 days out.
Sure, Madam Chair. And so if I was afraid for my own safety, then I would be limited to 15 days to be there.
Madam Chair, Senator Perry, that is how I'm reading that subdivision as well.
I will just note, though, that the exceptions seem to be, if there's an imminent threat of physical harm.
Madam Chair, I just, it seems like they carve out an imminent threat to physical harm, right, that I could stay, and then they go, and then the statute goes back and says, but actually you can't stay longer than 15 days. So it seems slightly, quite frankly, incongruous, and I just wanted to make sure that was the intention. I know sometimes we put a bunch of words on a page, and sometimes when we're moving things around, it doesn't always work out exactly how we want it. And so I was just checking with the patron. I don't know if that was intentional or not.
I would say to the patron that if this is voted out of rehab and it goes to finance, perhaps you can make an amendment. David.
Madam Chair, just one clarifying point. I believe that subdivision 5 wouldn't be when the inmate actually is requesting to be in there. It's when the facility administrator makes that determination, if that makes a difference for your situation.
Madam Chairman, I would just say, I always think it's a balancing here, right, where the Department of Corrections should be implementing all of the rehabilitative services they can. I'm a strong believer in that. And taking care of people and things like that. But they also have an obligation to protect people from harm who are within the facility. Because quite frankly, I think they're open to another lawsuit. If they're aware of threats to someone's safety, they have to protect that person. We have an obligation to those people to make sure that they are safe if we're going to have them in state custody. And so I just want to make sure we're balancing and taking care of that. And so I guess that would be my concern. It seems like we have a carve out and then another carve out. And I don't love the idea of, hey, someone else has threatened this person's safety, right? And so we put them in, trying to keep them safe, and then after 15 days, they could still have a threat to their safety, and it doesn't matter, you have to be released. And that just makes me concerned for that person, quite frankly. So those would be my concerns. Thank you. And thank you, Senator Packby.
I would ask the patron to think about that.
Yes.
And as you...
We'll definitely have some conversation around that.
Yeah, I mean, the carve out.
And talk to some...
I would encourage you to do that. I've got 2 other speakers, and then, colleagues, we have to move this along. We need to conclude by 9:30, so please be quick. Senator DeStef, I almost called you doctor. Senator DeStef, and then Senator McDougal.
Madam Chair, I'm going to be very quick, and if we could get DOC up real quick, I had a very quick question for them. While they're coming up, I'm just going to make one comment. In our jails, we have what's pink and green room, which isolate the individuals from those who would be victimized by anybody out there whatsoever. And we have individuals, no matter where you put them, if there's somebody else there, that individual is going to be victimized. So I think there's a little bit of work to be done here still, and I think Senator Perry was right on top of it. But Madam Chair, my question for DOC is, I know we had something similar last year. Do you have a financial impact, or do you know what this is going to cost? Because I believe last year was substantial.
Yes. So, Madam Chair, the fiscal impact is estimated to be a little over $8 million per year.
Thank you very much, Madam Chair. Thank you very much.
Okay, colleagues, we need to have a motion, and this needs to be re-referred to finance. Motion has been made and seconded, and it would be to report and re-refer to finance. Would the clerk open the roll?
Ayes 8, no 7.
Okay, Senator Pekarsky. And I believe you have a substitute. Is that correct? Okay. Could you, is that Senate Bill 529? Is that basically your substitute, or is it more than that?
No, I mean, I think you should. Yeah,
Okay.
That's all it is.
All right. Why don't you go ahead and talk to us about Senate Bill 391?
Thanks, Madam Chair. The substitute tried to address some of the questions we've got last time, but very quickly, again, 391 is a bill that seeks to protect the rights of public employees who are authorized to use medical cannabis. It provides a simple technical amendment to the already existing and agreed upon Medical Cannabis Employment Protection Code. And when it was originally enacted, there was no intent to exclude public employees from the code. The Employment Protections Code as I said, for medical cannabis patients. However, it was later discovered that the definition of employer in the code does not include public entities. Therefore, the code unintentionally restricted such protections from being extended to public employees. So now this further clarifies who is protected to include the Commonwealth, any county, city, town, or other political subdivision thereof, and any agency of the Commonwealth or such county, city, town, or political subdivision in that definition. The impacts of this unintentional exclusion were felt throughout the Commonwealth, but particularly amongst our firefighters who suffer from PTSD or other physical ailments. And this bill would, what this bill would do is prohibit public employers from discharging, disciplining, or discriminating against an employee when they are lawfully using medical cannabis for health purposes under the laws of our Commonwealth. It would not afford legal protection to someone who shows up at work inebriated, require employers to allow cannabis consumption during work hours, or interfere with restrictions that are already imposed by federal law. I know you are short on time. I know you're all going to support this. I do want, however,
I was not going to take public comment on this
yes,
because we
please
had
take public comment, because I think questions that were asked last time would have been answered adequately if we had allowed that. So if you allow them quickly?
Yes.
Unless you're all in agreement, and then
let us
we can all
first
go home.
adopt the substitute. Yes, David May. So it's not, that's clear. Okay, all right, very good. I was not clear if she had changed the substitute. Okay, we're fine, colleagues. The bill is before us, has presented. Yes. Okay, a motion has been made and to report. This is not going to finance, which is surprising. Okay, a motion is before us. Will the clerk please open the roll?
Ayes 11, noes 3.
Your bill reports.
Thank you.
Okay, let me see. I think I saw Senator Stanley. Senator Stanley, come before us and be brief.
I don't know about that. Thank you, Madam Chair, members of the committee. SB 724 is really to try to address a need that we have in Floyd County, where I represent. You may have heard of the festival called Floyd Fest. It's been there for a long time. What we have is Floyd Fest's new home in Czech, Virginia. Floyd Fest attracts 20,000 people to our region, brings in over $4 million of economic revenue, tax revenue to that as well. And what they're seeking is simply this, that they be added to Section G of 4.1.206.3, which allows an annual license, an annual mixed beverage license for those in performing arts centers, amphitheaters that already exist, that have more than capacity more than 5,000. Yes.
Senator Stanley, this is the third time we've heard this same bill for from different patrons. So the committee's very aware, and I think Senator Rouse has a motion.
A motion to report it.
Okay, will the clerk please open the roll?
This is the best rush job I've ever had.
Ayes 14, noes 0.
Thank you, Madam Chair. Thank you, members of the committee. Thank you, Senator.
Now, it's Senator McDougal, and then maybe Senator Favola will get in at the very last minute. Where's Senator McDougal?
He's gone.
All right. Well, then I will go ahead and present my report. My bill is Senate Bill 80, rather. Senator Servo.
Sure. All right, committee will turn to Senate Bill 80.
I have an amendment in the name of the substitute, and I ask that
Senator Rouse moves,
substitute
Senator
be
Williams
adopted.
Graves seconds to adopt the substitute. All those in favor say aye.
Aye.
Anybody opposed, no. Substitutes before us.
Okay.
Senator Favola.
This bill is, the substitute is substantially tighter and much shorter than the original bill. So what this does is it allows for a decrease in the probation time based on specific factors that the parole officer would have to verify. And the factors are laid out. If you look at B, paragraph 1, we're talking about educational accomplishments. Paragraph 2 talks about verifiable employment. And paragraph 3, the defendant is in compliance with any state certified or state approved mental health substance abuse treatment program. What would happen is that the probation officer, over a period of time, would evaluate the parolee's behavior, I think it's quarterly, and report to the court every 6 months. And that's the bill. I mean, that's the content of the bill. The value of the bill is it really encourages positive behavior. It allows an individual who's doing everything they're supposed to be doing to reduce their probation time and more fully integrate into society. This is what we're all about. This only applies to DOC parolees. It doesn't apply to, regional or local jail folks who were released. So it's another step in our strategy for really building a useful rehabilitation platform. I'm very pleased to present the bill, and I do hope it is the will of the committee to support it. I can ask people to comment on it, but I think I'm ready to answer questions. And
Okay, do any members of the committee have any questions for Senator Favola? Hold on, wait, we can't go that, I'd like it to go that fast, but we can't. First of all, is there anybody in opposition to the bill? Okay, is anybody online in opposition to the bill?
No, Sir Chair, but we have 2 who want to speak in favor.
Okay, we don't need support if there's no opposition, I don't think, unless Senator McDougal. Senator McDougal.
Can we just hear from DOC? Did they stand up? I'm sorry.
Nobody in the administration said anything. Is there anybody in the administration here to speak to the bill, DOC?
They are aware of the bill and had not indicated any concerns. I'm not going to say they support
I think I
it,
see
but I
DOC
haven't
out there.
heard
He
any
nodded his head in
concerns.
agreement to what you said. Okay, any other questions?
Okay.
He just gave a thumbs up for those of you at home watching on TV.
I think there's a motion before you.
No, not quite. You're good, DOC?
You just say you're good.
We oppose, Marcus Helam from Department of Corrections, we oppose, but it's basically for fiscal impact.
Okay.
Has to go to finance.
Yeah, clerk, that's go to finance.
I would just say with all due respect, some in our stakeholder group felt that it might actually be revenue added to the coffers because if the probation officer reduces his caseload because more and more people have a reduction in their sentence, it could result in actually a net positive.
I want to amend the motion to report, refer to finance.
It's been moved and seconded to report and refer the bill of finance. Any other discussion? Clerk will open the roll.
Ayes 15, no 0.
Committee will rise.
Senator McDougal.
Oh, just kidding. Darn.
Madam Chairman, members of the committee, this is Senate Bill 683. This came to me by the FACT, which is an entity that helps. It's the Family, Children's, and Trust Fund, and it's an entity that helps children and families as they're dealing with challenging times. The situation is that right now, because of the way the entity is organized, they fall under the state's procurement policies. And so as they're giving out grants, which is the majority of what they do, any grant greater than $80,000 has to go through that procurement process and not just a grant application. And it's taking on average 6 to 8 months and maybe even a little more to process any grant that's greater than $80,000. They advise that there are a number of investments that they would like to make into organizations that help children that are greater than in that 100,000 to 200,000 range, and they raise funds. So most of these grants are not even state funds. So over a year ago, they started the conversation with then DSS Commissioner Danny Avula, worked through the AG's office, and came up with this alteration to allow them more flexibility. That's what it does. It changes the organization to allow them more flexibility, be able to give bigger grants to help kids.
That's the beginning and end of the bill. It's very straightforward. Do you have anybody who wants to speak in favor?
Madam Chairman, I'm sure there are, but do you want to hear from them if you're okay with it?
Folks, if you're in favor, I think this bill's in good shape, so I can save you the anxiety of coming and speaking before us. Is anybody in opposition?
Motion to report.
All right. Motion has been made to report. Doesn't have to go to finance. The clerk open the roll.
It didn't
add you as a-
Oh, it did. Thank you.
Ayes 15, no 0.
Okay. Bill reports.
Madam Chairman, does that mean we save the best for last? Is that? Thank you, Madam Chairman.
I was going to be the last, but, you know. According to my notes, that concludes our docket for the day. So thank you, colleagues. And I don't believe we'll be meeting next week, but we'll have a robust, I have to check, but I think we've concluded our docket that I have to conclude before crossover. Is that correct? We continued your bill, and then we'll have fun with crossover. A motion to adjourn? And if there's a second, all those in favor signify by saying aye. We're adjourned.